So I'm gonna put the courtroom in the waiting room, Mindy, so that means we won't have audio for a bit until Mr. Malaro pops back in, all right?
Okay.
Judge, all I have is the amended information on Lewis. I think that's in the file.
Oh, I just sent it to Becky. I didn't send it to you, sorry.
It's okay. All right, hold on, Mr. Malaro, give me just a moment. All right, so we are on the record in the matter of the people of the state of Michigan versus Caleb Michael John Anderson. We have three files, file number 2022-21106FH, 2022-21127FH, and 2023-21247FH. I have this file. So for Malaro appearing on behalf of Mr. Anderson. Mr. Malaro, what is your P number?
42566.
All right, and I have Phoebe Meir appearing on behalf of the people. Miss Meir, your P number, please.
81059.
Okay, so this is the date and time that was scheduled for a plea in this matter. Miss Meir did provide to the court a copy of a plea agreement form dated February 9th of 2023 and signed by Isaac Sneed. Mr. Malaro, do you have that?
I do, Your Honor.
All right, so Mr. Malaro, how do you wish to proceed today?
So, Your Honor, pursuant to that plea agreement, Mr. Anderson will be pleading no contest to the plea as offered on 1106 FH, the added amended count 2, possession of a Schedule 1 or 2 narcotic, a 4-year felony. On the 127 FH file is charged to count 1, which is a
He's gonna
5-year
plead guilty or no contest.
Oh, no contest, Judge. On the 1247 FH file, count 1, the break and entering with intent, that's a 10-year D grid. And then as to the respective files on 106 FH, count 1 will be dismissed. 127 FH, count 2 will be dismissed. And 247 FH, count 2 will be dismissed. And then after the plea is completed, we'd like to address bond, Judge.
Okay, so Mr. Malaro on file number 22-21247 FH, was he pleading no contest?
Yes, Judge.
Okay, Mr. Sneed, I'm gonna guess did not tell you that, Ms. Meir.
No, but I can.
Do you,
please
Mr.
report.
Malaro, will you be able to place factual basis on the record, or do you need the people to?
I can do it, Judge, but Judge, it may not be clear, but the first sentence of the plea agreement, it says he could plead guilty or no contest.
Right, I understand, but Mr. Sneed is not able to be here, so I have Ms. Muir filling in, so that's why.
Yeah, I could
So Ms.
provide the
Muir,
factual basis.
okay, so Ms. Muir, it does say that on the first line, but I know that you're filling in, but Ms. Muir, is that your understanding of the plea?
It is.
All right, so Mr. Anderson, are you having difficulty hearing us?
No,
Okay, so when I swear you in, I need to see your face though, and your right hand. So could you sit down for a minute? All right, can you raise your right hand? Good. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, and you stood up. Is that because you're having difficulty seeing us?
No, it's just that I'm supposed to have glasses and I don't, so I can't see. It is because I can't see, but
Okay, all right.
you're
can you
good
state
though.
your- Okay, can you state your full name for the record, please?
Caleb Michael John Anderson.
All right, so, sir, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention on file number 22-21106FH to plead no contest to count 2, possession of Schedule 1 or 2 narcotic? Hold on a second. 6. Which, let me double check. I have a little information. Miss Adams or Miss Meredith, did you know if they did an amended information?
On file, would it be 2-7?
21106. I'm just asking, so possession of a Schedule 1 or 2 narcotic,
Yeah, I don't see an amended information, but I can prepare one, and that should be a 4-year, Judge.
that's what I was asking. Okay, so, so Mr. Anderson, is it your intention then to plead no contest to an added count 2 controlled substance, possession of a Schedule 1 or 2 narcotic, which, or I think I said no contest, which carries a maximum penalty of up to 4 years in prison? So is it your intention on that file to plead no contest to count 2?
Yeah,
Okay. Thank you. And then Mr. Anderson. So Mr. Anderson, then on file number 22-21127FH, find my felony information. Is it your intention to plead no contest to count 1, breaking and entering a motor vehicle with damage to of the vehicle, which carries a maximum penalty of up to 5 years in prison, as well as restitution? So is it your intention then to plead no contest to that count as well?
yeah,
All right, so then on circuit court file number 22-21247FH, Mr. Anderson, is it your intention to plead no contest to count 1, breaking and entering a building with intent, which carries a maximum penalty of up to 10 years in prison?
yeah,
Then you understand that all other counts in the files will be dismissed. Do you understand that?
yeah,
Are you satisfied with Mr. Malaro as your attorney and the advice that he has given you?
yeah,
Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Malaro?
That's correct, Your Honor.
Is that correct, Ms. Meaner?
That's correct.
All right, is that correct as far as you're aware, Mr. Anderson?
yes, ma'am.
Right, if a no contest plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. You understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial. Do you understand that, Mr. Anderson?
Yes, ma'am.
All right. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yeah.
All right. Do you understand that if you are not a citizen of the United States of America, the conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization? Do you understand that?
Yes, ma'am.
Do you have any questions about the rights that I've given to you?
No.
All right, so Mr. Anderson, and when I ask this question, if you wish to enter a plea of no contest, you're going to have to say no contest for each of these files. Do you understand that?
Yeah.
All right, Mr. Anderson, on file number 2022-21106FH, how do you wish to plead to the charge that on or about June 17th of 2022 in Rome Township in the county of Lenawee, that you did commit the offense of, under count 2, of possession of Schedule 1 or 2 narcotic?
No contest.
Okay. And Mr. Anderson, on file number 2022-21127FH, how do you wish to plead to the charge that on or about January 1 of 2022 in Woodstock Township in the county of Lenawee, that you did commit the offense of count 1, breaking and entering a vehicle with damage to vehicle?
No contest.
All right. And Mr. Anderson, on file number 2023-21247FH, how do you wish to plead to the charge that on or about February 22nd of 2022 in Woodstock Township in the county of Lenawee, that you did commit the offense of breaking and entering a building with intent under count 1?
No contest.
All right. Has anyone made any threats or promises to you to induce you to plead no contest to these charges, Mr. Anderson?
No.
Do you understand if I accept these pleas, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead no contest? Mr. Malaro?
No, Your Honor.
Ms. Neer?
No, Your Honor.
Has your attorney promised you any particular sentence or estimated what your sentence will be, sir?
No.
Is it your own choice to plead no contest on each of these files?
Yes, ma'am.
So, Mr. Anderson, I'm going to go back to file number 2022-21106FH. So, Ms. Meir, do you want Mr. Malaro, or are you prepared?
I was working on it, but if Mr. Malaro has it handy, it might be a little smoother.
All right, so Mr. Malaro, would you like to place factual basis on the record?
Yes, Judge. Judge, we believe that on or about June 17th, 2022 in Rome Township, County of Lenawee, State of Michigan, that Mr. Anderson was pulled over and had an interaction with Trooper Tadora. And that after that interaction, Trooper Tadora would be able to testify at trial and prove beyond a reasonable doubt that Mr. Anderson intentionally possessed a controlled substance that was in an amount of more than 25 grams, but less than 25 grams of a mixture or substance that is felony punishable by or imprisonment by not more than 4 years, and that it was a substance of an analog or prescription form unless the controlled substance or analog was obtained directly from a valid prescription. But Mr. Anderson would not have had, they would have been able to prove that Mr. Anderson would not have had a valid prescription for that analog. And we believe that they would have proven that beyond a reasonable doubt, and that Mr. Anderson knowingly possessed that analog.
And you said it was less than 25 grams?
According to the statute, Your Honor, it'd be more than 25, but less than 50.
All right, hold on.
More than 25, less than 50.
All right, Miss Mayor, any additions?
Just that the, yeah, I'm sorry, 1 second. What, do you know what actual narcotic it was or what analog it was?
I cannot
Mr.
speak to
Millar?
that.
Do I have a?
I would just
There's a
ask for a
schedule.
stipulation.
It's a Schedule
would
1
ask
or
for-
2 narcotic.
I would ask for a stipulation as to the true narc report then that was performed on June 27th, 2022. That, and it was the pill recovered by Mr. Anderson, and that test did come out to acetaminophen and methamphetamine.
We would stipulate to that.
Then I am satisfied, Your Honor.
Okay, so based on the facts placed on the record and information contained in the police report as cited and agreed to by council's court finds beyond a reasonable doubt that on or about June 17th of 2022, in Rome Township in the county of Lenawee, that Mr. Anderson was in contact with Michigan State Trooper Lance Tedora, and that he was pulled over, and that the trooper found in Mr. Anderson's possession a pill form more than 25 grams but less than 50 of a pill containing both acetaminophen and methamphetamine, therefore qualifying as an analog controlled substance, and that Mr. Anderson had no valid prescription for possession. And therefore, the defendant did commit the offense of possession of Schedule 1 or 2 narcotic, and the court will therefore accept the no contest plea on that file. All right, so now we're going to move on to file number 2022-21127F, where the defendant did plead no contest to count 1, breaking and entering a vehicle with damage to vehicle. So, Mr. Millar, would you like to place a factual basis on it?
Yes, Your Honor. Your Honor, we believe that Trooper Lance Tedora on or about would be able to prove beyond a reasonable doubt on or about January 1st of 2022 in Woodstock Township, County of Illinois, State of Michigan, that Caleb Anderson did enter and break into a 2010 Keystone camper with the intent to unlawfully remove property therefrom, and did in one form or another cause damage to the vehicle to gain entry. That this would be a 5-year felony, Class G felony. We believe that
What was the damage to it caused by breaking in?
I think it was a door, Your Honor. I could be mistaken, but I think it was the door. And we believe the people will be able to prove that beyond a reasonable doubt.
And to the amount of damage, can you speak to that?
It doesn't require.
I don't think that the value of the damage is required.
No, it's not listed.
Okay,
Just that damage. Okay.
okay, thank you.
Okay. All right, are you satisfied with that?
I am, Your Honor.
All right, so based upon the facts placed on the record and from the information contained in the police report as recited and agreed between counsel, court finds beyond a reasonable doubt that on January 1 of 2022, Woodstock Township in the county of Lenawee, that the defendant did break into a 2010 Keystone camper, which is a trailer, And that by breaking into it, damaged the door and lock system to steal or unlawfully remove property from the interior. Was property removed, Mr. Millar?
I'd have to look at the probable cause affidavit, Judge.
Looks like a television, Ozark folding chair, Edison string light, hand axe. And Mr. Millar, is that the information in the police report? It would be count 2. Some of the items removed at count 2.
I don't see what the property was that was listed, Judge.
It's in
Yeah,
that
perhaps it was
felony.
a folding chair, and a television, and a hand axe.
And then when breaking into the trailer, would you agree with that, Ms. Smith?
Yes.
Did take unlawfully remove property from that. Okay, and therefore the court finds the defendant did commit the offense of breaking and entering a vehicle with damage to vehicle and accepts the no contest plea. Okay. So let's move on to file number 2023-21247FH. The defendant pled no contest to count 1, breaking and entering a building with intent. Mr. Millar, would you like to place factual basis on the record?
Yes, Your Honor, we believe that if this has gone to trial, the state would be able to prove beyond a reasonable doubt via testimony from Trooper Lance Tedora that on or about February 22nd, 2022, in Woodstock Township, County of Illinois, State of Michigan, that Caleb Anderson did break and enter into a pole barn located at 10255 Harold Highway in Addison, Michigan, with the intent to commit the crime of larceny by taking tools and certain other items located in that barn.
All right, and how did
Mr.
break and enter
Anderson
it?
did not have permission to take those items
Okay, how did he enter the barn?
through one of the doors.
All right. Ms. Meir?
I'm satisfied, Chair.
All right, so based upon the facts placed on the record and from the information contained in the police report as recited by Mr. Millar, and agreed to by Ms. Meir, the court finds beyond a reasonable doubt that on or about February 22nd of 2022 in Woodstock Township in the County of Illinois, the defendant did commit the offense of breaking and entering a building with intent by entering a pole barn located on Harold Highway in Addison, Michigan, with the intent to commit the crime of larceny therein by taking tools, saws, cameras, among other items without permission. They had no right to be there. Therefore, the court does accept the no contest plea on that file. So has the court complied with MCR 6.302 B, C, and D? Mr. Millar
Yes, it is.
and Ms. Meir?
It has.
Accept the pleas. They've been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence. In this case, the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. And Ms. Adams, I forgot to request a probation officer. Is there anybody
Okay.
over there?
Okay.
Probably Mike Stevenson is there. All right, so Mr. Millar, are you available on Friday, April 28th for sentencing?
I am, Your Honor.
All right. So, Mr. Anderson, I'm going to set this for sentencing on April 28th at 8:15 in the morning. Either here in a few minutes or at a later date, someone from the Michigan Department of Corrections is going to reach out to you. They're going to give you instructions, a packet to fill out, and instructions to follow to meet with them, whether you're in custody or out. We haven't made that determination yet. When you meet with them, be truthful about your background. Obviously, you entered a no contest plea, so you don't have to make a statement about the events that occurred, and the court does understand that. They'll prepare a pre-sentence report. A copy of that will be provided to the public defender or your attorney, as well as, I believe, a copy is provided to the prosecutor's office. You'll get an opportunity to review that and discuss that with Mr. Malaro prior to sentencing. So I'm just waiting for someone from the Michigan Department of Corrections. Mr. Stevenson, I'm going to print off a copy of the plea agreement form in this. I apologize, I forgot to call you over here. I pulled these this morning, so I'm going to print this off for you. So he pled no contest on each of these files. And I'm setting sentencing for April 28th at 8:15 in the morning. Before I decide how you're going to speak with him, Mr. Malaro, you stated you wish to address his bond.
Yes, Judge. Mr. Anderson lives here in Lenawee County. He's a long-term resident of the county. I've represented him for a considerable period of time on these matters. He has been in custody since October of last year. He is under a sentence which for contempt citations out of district court, and I think some other matters. That sentence ends tomorrow. You'll be up from that tomorrow. Been talking to Mr. Anderson about resolution of these matters. He's been cooperative, been willing to resolve these matters in a timely fashion once we got them in a position to be resolved. I am under the belief that he would appear at all court appearances. It'd be in his best interest to do so. And so we're asking the court to consider reducing his bond to a personal recognizance bond for several reasons. Mostly that if he is released tomorrow, he can, one, there's going to be a restitution issue. He can begin working on that issue and hopefully show the court he takes this seriously. And so I think that's one, and I think that's an important factor. I think if Mr. Anderson's able to begin working on restitution and comply with whatever requirements this court has, number one, I think it'd go a long way towards his rehabilitation, but also show the court that Mr. Anderson's ready to move on and become a productive member of society. So that would be our request, Your Honor.
Ms. Adams is Mr. Host here as well. Are you here for Mr. Roberts? Oh, okay. Or I mean, Mr. Anderson? No, okay. Ms. Meir?
The only thing I'd like the court to consider is that Mr. Anderson is alleged, well, he's pled now. He has committed these offenses while I believe he was out on bond in district court on one of them, and that's where this contempt came from. And that's my understanding of it. And I'm sorry if I misspoke. But as long as the court considers that and just Mr. Anderson assures us that he's going to appear for sentencing, I'll leave it in the discretion of court.
All right. So Mr. Anderson, where are you going to go live?
I'm going back to my house in Manitoba Beach, my stepdad's house.
Okay. And okay, and is that, it's not Jerome, Michigan, isn't it? Is it?
No, it's Devil's Lake, Manitoba Beach, Michigan.
And what is your hold on a second. Because we don't have an address for you. All right, so sir, what is your address?
It's 700 Devil's Lake Highway. And then Manitoba Beach, Michigan. And zip code is 49253.
All right. So sir, okay, so I'm going to release you on a care bond because you have served a period of time on this. And I'm gonna put in some requirements. One, you're not to use any controlled substances or alcohol. You're not to commit any crimes. You are to do random testing, all right? So not for alcohol, but random testing for drugs, okay?
Yep. I've got to do that for my downstairs. I'm gonna be on probation downstairs too, on misdemeanor stuff. And then I have a CPS case open too, so I'm gonna be doing random drug testing for that stuff too, so.
Okay, you won't have to do it twice. We'll just get those records, okay?
Okay,
And no contact with any of the victims on these files. Do you understand that?
yeah.
Okay.
I don't even know who's on the files. It
Okay,
should just be me on them, I think, but.
What, no, like the owner of the camper and the owner of the pole
Oh.
barn camp.
Okay,
Yeah. I mean, you're kind of your own victim. You're right on that, but I meant these people as well. So those would be the terms of your bond, and you must comply with your probation terms. Mr. Stevenson, do you want to Zoom with him real quick from your office?
Just his phone number, if I can get that.
All right, can we get your phone number, Mr. Anderson?
right now, when I came into jail, my phone number was,
Well, you probably don't have.
I don't, it was an Obama phone, and I just had got it, but I had to give it to my baby mama, and I don't know where it went, so I'm gonna have to get out and get a phone and stuff, so I don't have a phone number.
Hold on, I can't hear you. You're really muffled. So I'm gonna get the gist that you don't have a phone. So,
He has an alternate contact number, a parent, girlfriend.
do you have a parent's phone number?
I can give you my stepdad's phone number. My woman's in jail right now too, so.
Okay, what's your
Stepdad is
stepdad's?
517-260-1815.
Okay, and then report to you
When he gets out.
today?
Yeah.
Okay, or tomorrow. Okay, so he'll get out of jail
Now,
tomorrow. All right, so,
I'm gonna be released tomorrow. It sounds like, I have some other matters that I have to deal with in, Hillsdale too. So I might get picked up from here and go straight to Hillsdale.
okay,
So
okay.
if I don't come in tomorrow, as soon as I get released from there, I'll be in that day.
All right, so Mr. Anderson, as soon as you get released from jail, Monday through Friday, 8 to 4:30, we're open. I need and close for lunch 12 to 1. I need you to come in and check in at the circuit court probation department on the 3rd floor. So I understand you
Okay.
got probation down on the 1st floor. You got some
Yeah.
stuff going on the 2nd floor, but 3rd floor probation is where we're at. So you'll need to check in, just give them your name and they'll give you direction. If you don't, I'll issue a bench warrant. Got it?
Okay.
Judge,
Yes.
Okay.
is
Ms.
that,
Adams?
sentencing via Zoom? Did we say?
No, it's gonna be in person. I want sentencing in person. Okay, all right, and your sentencing is April 28th at 8:15 in person. All right, Mr. Anderson?
Okay.
Okay, very good. Thank you.
Thank you, Judge.
We're done.
May I
All
approach?
right.
Oh, yeah. Thank you, Mr. Anderson.
All right. Thank you. Have a good day.
You too.
This is a signed copy of this from Mr. Milan, and then this is what I wrote up on the records, if that's helpful. Or else we can make copies, Mr. Stevenson,
Yeah, Ms. Adams, could I get a copy of these?
and for me, that's all.
Can I get 2 copies of this paperwork?
Well, I have just, this is just the Kyle Roberts one. I'm sorry. Yeah, let's see. And I sent that to Sam.
Mr. Malaro, did you get a copy of the plea offer on Mr. Roberts?
I do, and Your Honor, I
You need to
cannot
break
imagine.
out.
Do you not understand it, Sam?
No, I understand it. It's just that I cannot imagine this, he's gonna remember any of this. So I'm gonna ask if he can do a no contest.
That's fine.
Okay, All right, so do you need a breakout with Mr. Roberts? Because I have Mr. Mawad here and I can take his client.
Yeah, let me do a breakout, Kyle, and then Mr.
Okay,
Mawad can do his thing.
all right. Mr. Roberts, I need you to turn on your video and unmute your device. All right, so Mr. Roberts, I'm going to put you in a breakout room with Mr. Malaro.
All right.
And hold on. So let me assign Mr. Roberts and Mr. Malaro. I'm gonna open that room. I'm gonna go get a copy of this for Mr. Stevenson.
Thank you.
Yep.
Yeah. Probably, if you've gone over it.
Yeah,
Is it
go-
no conflict?
No,
Okay,
I
so
think
yes.
because you want to be.
Yeah.
So
So if you've gone over it.
I am, plus you have the elements of the student.
Yeah, I wasn't sure which variable to put in for our amended. So that's what but that's not the-
Oh, that, yeah, do they have the student second, but no.
No,
So
that's
there's no
why,
variable. Yeah, you're right.
that's why I put it
Yeah,
under,
It's not gonna matter, it's the same sort of, it's the same, guidelines and all that stuff.
exactly. Yeah.
So you, is your Vic gonna be on?
No, she's not. I thought she was going to.
And how's Nancy doing?
Good, she just got back from Hawaii. I'm gonna go see her tomorrow, actually.
I mean, it's got fine, so, yeah.
Yeah.
Shredder, I know, sure.
I don't know.
Well, now he can't, he can have too much on the sky, those guys.
I doubt it.
For her, though.
Maybe just take the stuff back.
Yeah, yeah.
But they're painting my office downstairs, so
Oh,
I moved into her old office
Okay.
temporarily
okay.
while they're painting, and I found a bunch of stuff. So
Yeah.
it's an excuse to go see her.
Yeah. I hear, tea time is 3 o'clock on Friday.
That's what I heard. Probably not this Friday, though.
Probably.
Because Burke will be out celebrating his birthday.
And it's, yeah, try to say that. Oh, boy.
Yeah, he does something big every year.
Good for him. Where's your partner, Frank? Well, they got dropped, which in Jada or
It has to be, because I think more than small, yeah.
Lakes. Okay, well, I gotta do a plea.
Downstairs, you know.
Yeah, but that's okay. I want to get this done.
Maybe she'll hurry up and get stuff done before the trial.
Yeah, it's just, is Chris here?
Chris and I think are both.
Okay. Okay.
Normally I would. It's okay.
All right. Did I not open the breakout room, Mr. Miller?
No, Judge, we're done and ready to go.
Okay, I'm still gonna take Mr. Mawad first because I think it'll take quite a period of time on Mr. Roberts, so
Sure,
let
you like him
me,
better, I understand.
well, you know.
I like him better than me too, so it's okay.
I love you, Sam. Love you, man.
All right, so that's that one. That. All right, this is in the matter of the people of the state of Michigan versus Jesse Ryan Lewis, file number 2022-20699H. And counsel, I do have a new court reporter today, so could you identify yourself by name and P number?
Elias Muad, MUAWAD, and my P number is 41632.
All right,
And Phoebe Mir on behalf of the people, P 81059.
right, and Mr. Mawad, you have Jess Ryan Lewis standing next to you. This matter was scheduled for a plea today, and I do have a copy of a plea agreement that I have received. Mr. Mawad, how do you wish to proceed today?
Your Honor, it is my understanding pursuant to a plea agreement that Mr. Lewis will have the benefit of pleading guilty to amended count 6, which is criminal. 5, so sorry. Oh my God, my eyes. 5, sorry, which is criminal sexual conduct in the 2nd degree. It is my understanding that counts 1 through 4 shall be dismissed. There is an agreement whereby Mr. Lewis, upon sentencing, will be sentenced to 1 year in the Lenawee County Jail. Also, it will be 5 years probation, and both myself and Ms. Mir confirmed all this with Mr. Jones. Thank you. Oh my God. And then my client's going to be on the 25-year SORA. He understands that also. My client also has to admit to a penetration that occurred. That's part of the plea.
All right, so sexual contact and 1 penetration.
That's correct, Your Honor, and that with the guidelines on the CSC second, that does put it higher than 1 year in Lenawee County Jail, but we have made that agreement via a Killebrew agreement to no more than 1 year in Lenawee County Jail. But just so you're aware, at sentencing, the guidelines will be a little bit higher than that. And by my estimation, I don't know exactly what Mr. Jones will come up with, but.
Okay. All right. So, sir, can you raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? All right, can you state your full name for the record?
Jess Ryan Lewis.
All right, Mr. Lewis, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count 5 criminal sexual conduct 2nd degree?
Yes.
All right. Are you satisfied with Mr. Mawad as your attorney and the advice that he has given?
Yes.
Do you understand the maximum penalty for this offense could be up to 15 years in prison, but there is a Killebrew agreement that an initial sentence would be no more than 1 year in jail.
Can you clarify that for me?
Okay, so the maximum penalty on this offense is up to 15 years in prison. But for that agreement, you probably would have been serving a prison term on this. Do you understand that? A Killebrew agreement is an agreement between the prosecutor's office and your attorney that sets a sentencing. So your initial sentencing, when you were sentenced on April 28th, will be to 1 year in jail. Now, if you violate probation or get in trouble, then you would be facing up to 15 years in prison for sure. Do you understand that? Do you have any more questions on that?
No.
All right. Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Mawad?
That is correct.
Ms. Mir?
That's correct.
All right, and as far as you're aware, sir, is that correct?
Correct.
Okay. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Sir, do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable had you been convicted at trial? Do you understand that? Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. And it's been stated on the record, but do you understand that by entering a plea to this offense, you will be required to register under the Michigan Sex Offender Registration Act for a period of 25 years? Okay. Do you have any questions about the rights that I've given to you?
No.
Is there any additions?
No, thank you.
Okay. Sir, how do you wish to plead to the charge that on or about October 1 of 2019 in Adrian Township in the county of Lenawee, that you did commit the offense of criminal sexual conduct, second degree during felony? Okay,
Judge, we're gonna clarify the time. Could you just make it October of 2019? Because this happened towards the end of October. We're with permission. Are you okay with that?
I would say through November 1st.
Through November 1st, October
Okay.
1st through November 1st.
so you'll amend that information to reflect that time?
I can do that, yeah.
Okay,
I just wanted to make that.
all right,
Thank you.
okay. And Mr. Lewis, you have no objection to that amendment? From October 1 through November 1 of 2019?
No.
Okay, all right. Has anyone made any threats or promises to you to induce you to plead guilty to this charge, other than what's placed on the record? All right. Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that? I need you to speak up, okay?
Sorry.
Because my court reporter is zooming in,
Sure.
so. Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Mawad?
None.
Ms.
None.
Meir?
None, Your Honor.
So we did place a Killebrew agreement on the record, sir, about the jail term. But other than that, has your attorney promised you any particular sentence or estimated what your sentence will be in terms of fines and costs and restrictions? I know that there is an agreement on the record that it would be a 5-year probation term, but other than that,
Just the 5 years and the 1 year Lenawee County Jail.
okay. Is it your own choice to plead guilty?
Yes.
All right, so Mr. Mawad, do you wish to voir dire your client?
Yes, because there's some various elements, at least that ties in from the third degree to the second.
And then
degree.
Ms. Meir can then ask further questions.
Absolutely. Mr. Lewis, I'm going to ask you some questions. In order for the judge to accept the plea, we have to meet the elements of, we have to meet the Killebrew agreement plea. So between October 1st, 2019 and November 1st of 2019 in Adrian Township in Lenawee County, you were in contract or under contract as a golf pro for the Adrian Public Schools, correct?
Coach.
Or coach, correct? Yes?
Yes.
Okay. At that time, and I can only mention initials, I'm not going to mention the full name, you understand that? One of your students was a student that had initial TV, correct? Yes?
Yes.
Okay, just so it's clear. At some point in time, there was an event on your property between those dates whereby TV and you were the only ones left at your end of the year party for all of your students, correct?
Yes.
And at that event, at some time that night, there was sexual conduct between you and TV, correct?
Yes.
And the sexual conduct was basically penetration from your penis to her vagina, correct?
Yes.
You agree to that?
Yes.
All right. It is also part of the, let me just check, Judge. I'm looking at my phone because I just want to make sure I get it right here. Yeah, that's fine. During this time period that you had sexual conduct or sexual criminal conduct with her, there was also touching of either her breast or her buttock or her vaginal area, correct?
Yes.
All right. Other than that, I'm going to turn it over to the assistant prosecutor who may have more questions.
I just have, I believe, 2 follow-up questions. Do you agree that the student with the initials TV was at least 16 years old, but less than 18 years old?
Yes, I believe so.
And the only reason you had any contact with her, or even knew of her, was because she was on your golf team? Or that you coached her in some way?
Yeah, I guess, yeah. Yes.
That was the one question I forgot to ask. It's the second one, but that's correct. She's correct.
I'm satisfied, Your Honor.
Jeez, Mike.
Has the court complied with MCR 6.302 B, C, and D? Mr. Mohan?
Yes.
Ms. Meir?
It has.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement or has heard and will honor the Killebrew agreement that was struck. But other than that, has made no agreement regarding the possibility of a plea or possible sentence in any other way with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. Mr. Mawad, are you available April 28th at 8:15 in person?
One housekeeping matter before we get into that, if that's okay. I just have to ask him this question because it's mandatory on the plea. You understand that you're going to be on the 25-year sex registry under the sex registration. And you're going to be meeting with Mr. Jones to take care of all that. Other than that, Judge, would you adjourn it? Would you give me a little bit more time to allow him to get his affairs? With the court can do that, but in person's fine. That's not an issue.
Well, I was, okay, so that's 6 weeks. Ms. Adams, Ms. Adams, I'm looking for May 11 or 12. Or May 4
May 12.
or 5. Right, May 12 at 8:15 a.m. Are you
Yes,
available in person?
Yes, I will make myself available, and it is in person. I believe I have something else in your court on that date, but I think I'm sending an email to see if we can get an earlier date for a plea. What's that?
How do you know?
I don't know. I'm gonna be 60 this year. I can't even know if I can remember anymore too much.
All right, so we will set sentencing for May 12 at 8:15 in the morning. That will be in person.
Judge, I do hate to do this because I know it's hard. I am gone the 11th and 12th.
Oh, okay.
And I'd rather be here with.
No,
Trinity
that's
and-
fine. Ms. Adams, May 25 or 26.
Both those dates work for me.
That's fine, whichever.
May 25th.
May 25.
Yeah.
So we'll set it for May 25 at 8:15. That'll be in person. All right, so Mr. Lewis, I'm gonna have you step across the hall to the Michigan Department of Corrections. They're going to give you a packet to fill out instructions on when to meet with them. You'll be meeting with Chris Jones. When you meet with them, be truthful with him about your background, the events that occurred. They'll prepare a pre-sentence report. We will provide that to Mr. Mawad and Ms. Meir. You'll get an opportunity to review that with Mr. Mawad, and we will see you back here on May 25 at 8:15 in the morning. All right, so just step across the hall and have a seat.
Thank you, Judge.
Thank you. Mr. Jones here.
He won't be able to come down.
No, and then I've got like, one more.
Yep, I'll come back.
Okay,
I gotta drop that off.
okay, you got the paperwork on the next one already.
If everyone can understand.
He's here, but yeah, he just got to see the lot.
Okay. Thank you.
Yeah.
Thank you, guys.
All right. So. What are you waiting for?
That's P here for Elizabeth Warner. The people against Elizabeth Warner.
Ms. Adams? Was Elizabeth Warner scheduled today?
I will look that name up.
They gave me a number to call here to see if the trial was, or, she's still gonna be, but it only talked about Wednesdays. They never said anything about today's. And I didn't want to be upset, so.
Okay.
Are
hold on.
are you Amanda?
No.
Judge,
Yeah,
she pled and it's scheduled for sentencing April 21st at 8:15.
was this originally a trial date?
Yes,
So I didn't.
So when you called last night, you didn't,
No, I called after 4:30 like they told me to.
you didn't hear anything?
No, it was
Okay.
everything for Wednesday. It was 2 people for Wednesday. Now, I didn't say anything about her, so I missed work today to be here. So there was a peanut.
So I'm sorry. I apologize.
Okay.
Yeah, I am sorry about that. If you want to step down to our office, we might be able to get you a witness fee. I know it's not much, it would be something.
Where's that at?
Second floor.
What's it called?
Oh, witness fee. Just
Just
tell them that you.
What office am I
The
going to?
prosecutor's office.
Oh, yeah, the second.
Yeah,
Okay.
just tell them that you were subpoenaed for the day.
And what was your name?
Fee.
Phoebe, okay, right, thank you, thanks.
Okay, so, Mr. Malaro, we have a lot of files, so, you're gonna have to bear with me, all right?
Yes, I will, Your Honor.
All right, so this is in the matter of the people of the state of Michigan versus Kyle V. Roberts. I have file number 2023-21233 FH. 2023-21234 FH. 2023-21235 FH. 2021-20678 FH. 2021-20383 FH. 2021-20215 FH. 2019-19684 FH. 2019-19685 FH. And 19-19686 FH. I have Salvatore Malaro appearing on behalf of Mr. Roberts. Mr. Roberts is appearing via Zoom, and I have Phoebe Muir on behalf of the people. Mr. Malaro, your key number?
42566.
Ms. Muir?
81059.
All right. So, Mr. Malaro, you had scheduled this for today for a plea. I have received a document that Ms. Muir wrote out listing each file as to whether, so for example, it said, well, I'm going to read through it. So on file number 2023-21235 FH, on the absconding file, it states that he will, I'm going to go through one, please. Be pleading, and I believe you were asking for a no contest for lack of memory, right?
Yes, Judge.
All right, so he's going to plead no contest count 1, absconding, is that correct?
That's our understanding. Yes, Judge.
All right, so let me go through and try to. All right. And then I have file number 2023-21234 FH. That file is to be dismissed at the time of sentencing. Is that correct, Ms. Muir? That's correct. Is that correct, Mr. Malaro?
Yes, Judge.
And then file number 2023-21235. No, I'm sorry, I had these backwards. Hold on a second. The plea was on 35. I'm sorry. So let me correct that. File number 23-21233 FH is to be dismissed. File number 23-21234 FH is to be dismissed. And on file number 23-21235, that's the file he is to plead guilty to count 1 absconding, which carries a maximum penalty of 4 years. So he would plead no contest on that file. Is that correct, Mr. Malaro?
Yes, Your Honor.
Ms. Muir?
Yes.
Sorry. Okay, so, all right, so then let's make sure my files are in a different order. So This is 7-8. All right, so on file number 2021 dash 20678 FH. He will plead guilty to count 1, controlled substance, possession of methamphetamine, ecstasy, without the second offense?
Correct,
Okay, so it would remain a 10-year felony.
correct.
Okay. All right. So is that correct, Mr. Malaro?
Yes, Judge.
All right. So, okay, it wouldn't be the possession of meth. It's just, okay, just a second, it's got it, right? And then I've got file number 21-20383 FH. That file would be dismissed, correct?
Correct.
All right. And file number 2021-20215 FH would also be dismissed.
Correct.
And then file number 2019-19686 FH.
You should have an amended information on that, so it would be a plea to the amended or added count possession of cocaine.
Ms. Adams, do we have an amended information on that one?
I do not, Judge.
Okay,
I can
it's okay.
email it.
All right.
I have one.
So he'll be pleading to count 2 possession of cocaine. Okay. So he'll be pleading no contest to count 2 possession of cocaine. All right, and then 2019-19684 FH to be dismissed. And then on file number 2019-19685 FH, he's going to plead to count 1, possession of controlled substance fentanyl, which carries a maximum penalty of up to 4 years. All right, so Mr. Malaro, does that appear to be a correct recitation of the plea as you understand it?
And that Mr. Roberts has been approved for drug court, Your Honor.
Okay,
With that addition, yes, that's a correct recitation.
okay, all right. All right, does that sound right, Ms. Mayor?
Yes.
I think I got it. Okay. So, Mr. Roberts, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, can you state your full name for the record, please?
Kyle Lee Roberts.
All right, so Mr. Roberts, you have heard the statement of your attorney, the prosecuting attorney, and myself reciting the plea. Is it your intention on file number? Okay, so is it your intention on file number 23 on file number 2019-19685 FH to plead guilty to count or plead no contest, you said, Mr. Malaro, right?
Correct.
Plead no contest to count 1, controlled substance, possession of fentanyl less than 25 grams, which carries a maximum penalty of up to 20 or 4 years in prison. So is it your intention to plead guilty on that file?
No
Judge,
comments.
For clarification,
contest.
you meant 4 years, right?
Yeah, 4 years, sorry.
Okay.
So is it your
Sorry.
intention on that file to plead no contest to possession of fentanyl, which carries a maximum penalty of up to 4 years in prison?
Yes.
Okay, sorry. All right. Okay, so then On file number 2019-19686 FH, is it your intention on that file to plead to count 2, possession of cocaine, to plead no contest to count 2, possession of cocaine, which carries a maximum penalty of up to 4 years in prison?
Yes.
All right, so then. On file number 2023-21235 FH, is it your intention to plead no contest to count 1, absconding or forfeiting bond, which carries a maximum penalty of up to 4 years in prison?
Yes.
All right, so then, this file. So then on file number 2021-20678 FH, is it your intention to plead no contest to controlled substance, possession of methamphetamine without a second offense, and that carries a maximum penalty of up to 10 years in prison?
Yes.
Okay, so, all right. So, Mr. Roberts, are you satisfied with Mr. Millar as your attorney and the advice that he's given you?
Yes, Your Honor.
All right. Other than you've been approved for drug court, has neither your attorney, the prosecutor, nor anyone on, well, so neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with court other than he has been approved for drug court. Is that correct, Mr. Millar?
That is correct, Judge.
Ms. Meir?
That's correct.
And Mr. Roberts, is that correct as far as you're aware?
Yes.
All right, so if a no contest plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty. You do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Roberts?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you, Mr. Roberts?
No, Your Honor.
All right, so Mr. Roberts, your attorney stated that you're going to be entering a no contest plea. So when I ask you how you plead, you're going to have to say no contest. Do you understand that?
Yes.
Okay, so Mr. Roberts, on file number 2019-19685 FH, how do you wish to plead to the charge that you did commit the offense on June 20th of, all right. How do you wish to plead to the charge that on or about June 20th of 2019 in the city of Adrian in the county of Lenawee, that you did commit the offense of controlled substance, possession of fentanyl less than 25 grams?
No contest.
Okay. And on file number 2019-19686FH. Sir, how do you wish to plead to the charge that on or about October 6th of 2019, in the city of Adrian in the county of Lenawee, that you did commit the offense of possession of cocaine?
Yes.
All right, possession of cocaine that carries a maximum penalty of up to 4 years in prison.
No contest.
And then let's go on to file number 2021-20678 FH. Mr. Roberts, how do you wish to plead to the charge that on or about September 24 of 2021, the city of Adrian in the county of Lenawee, that you did commit the offense of controlled substance possession of methamphetamine?
No contest.
Okay. And on file number 2023-21235 FH, how do you wish to plead to the charge that on or about April 28, 2022, in the city of Adrian in the county of Lenawee, that you did commit the offense of count 1 absconding or forfeiting the bond?
No contest.
And has anyone made any threats or promises to you to plead no contest to these charges other than what was placed on the record?
No, Your Honor.
Do you understand that if I accept these pleas, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, Your Honor.
Is the defense counsel or prosecutor aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Malaro?
No, Your Honor.
Ms. Meir?
No, Your Honor.
All right, Mr. Roberts, has your attorney promised you any particular sentence or estimated what your sentence will be?
No, Your Honor.
All right, is it your own choice to plead no contest to these charges?
Yes, Your Honor.
All right, so it's a no contest plea. Who's going to be Ms. Meir?
I can, Your Honor, just, I'll have to jump between the files, but I'll try my best.
Okay, all right, so, Mr. Malaro, Ms. Meir is going to place factual basis on the record, and then you can make any additions if you need to.
Okay.
So starting with file 2019-19685 FH, the people would say that they could prove beyond a reasonable doubt that on June 20th, 2019, Officer Merilat, MERILLAT, of the City of Adrian Police Department did initiate a traffic stop on Division Street near Dawes Street, and at that traffic stop, Kyle Roberts, the defendant in this case, did identify himself as a Brandon Lee Prophet. They recognized him as Mr. Roberts, and when they arrested him or something, I'm trying to see. Either way, they did effect an arrest on Mr. Roberts at that time, and during a search of his person, they located an amount of white residue in his back left pocket. And when they tested that residue, it did come back positive for fentanyl, which is a controlled substance, Schedule 2.
Mr. Malaro, any additions?
No, Your Honor.
So on file number 2019-19685FH, based upon the facts placed on the record by Ms. Meir and from the information contained in the police report, the court finds beyond a reasonable doubt that on June 20th of 2019 in the city of Adrian in the county of Lenawee, that the defendant did commit the offense of controlled substance possession of fentanyl by having fentanyl on his person and residue in his pocket with no legal right or authority to possess it. All right, so accept, therefore the court accepts the no contest plea on that file.
As it relates to file 2019-19686 FH, that the people would be able to prove beyond a reasonable doubt that on October 6, 2019, in the city of Adrian on West Maumee, Officer Putnam was involved in a traffic stop on an individual whom he identified as Kyle Roberts, or who he recognized as Kyle Roberts, and who he knew to have warrants upon effectuating that traffic stop, and ordered Mr. Roberts out of the vehicle. They had found in the vehicle within hand's reach an amount of suspected controlled substance. It would have been a white grainy residue that was later tested and did test positive for methamphetamine, but for the purposes of the factual basis, the lesser offensive possession of cocaine.
Mr. Malaro, are you satisfied?
We're satisfied, Your Honor.
Now, Mr. Roberts, do you understand that offense may or may not have some impact on your driver's license? The laws
Yes,
changed, but I'm not sure how a 2019 offense would be treated. So do you understand it could have an impact on your driver's license?
Yes, okay, yeah.
Okay. All right, based on the facts placed on the record and from the information contained in the police report, the court finds beyond a reasonable doubt that on October 6th of 2019, in the city of Adrian, in the county of Lenawee, that Mr. Roberts did have in his possession a controlled substance, methamphetamine, for purposes of the plea, though we're going to plead to the lesser, without legal authority or prescription or right to possess, and did intentionally possess it. So therefore, accept the no contest plea to the lesser offense of possession of cocaine. Takes care of that. Oh, so Ms. Muir.
As it relates to file 2021-20678 FH, that the people would be able to prove beyond a reasonable doubt that on September 24th, 2021, in the city of Adrian, Officer Boudreau, that being Boudreau, was dispatched to the area of Molzer Ave for a noise complaint. He was able to pinpoint that noise complaint to a vehicle, and in that vehicle, he identified the defendant Kyle Roberts, and knew him to have bench warrants out of the city of Adrian Police Department. They had ordered everyone out of the vehicle, including Mr. Roberts, and upon a search of Mr. Roberts, they did locate a clear tied plastic baggie with an unknown white substance that was later tested and did test positive for methamphetamine.
All right, are you satisfied with that one, Mr. Malaro?
We are satisfied, Your Honor.
All right, based on the facts placed on the record and from the information contained in the police report, the court finds beyond a reasonable doubt that on or about September 24th of 2021 in the city of Adrian in the county of Lenawee, that the defendant did have in his possession methamphetamine, which is an illegal controlled substance, and he had no right or authority to possess, and that he knew it was methamphetamine. Therefore, the court does accept the no contest plea. Okay. I believe we have one follow-up.
Yes, so finally, on file 2023-21235 FH, the people would just ask for a stipulation that Mr. Roberts, as identified here today, did have a number of pending cases in front of both the circuit court and district court, including a number of the file numbers that were mentioned here today, and that he was scheduled and ordered to appear before Your Honor, Judge Anzalone on Wednesday, April 27th, 2022. And that he did fail to appear for that. And in these files that we've mentioned today, there were felonies that were charged, and it was a felony that he failed to appear on while out on bond for those felonies.
So the felony information says April 28th, but the probable cause is April 27th.
It would be the 27th. That must be a typo on the 28th, but it was the 27th on a Wednesday morning.
Mr. Malaro?
Yeah, we would agree with that, Judge, that he was
All
obligated
right.
to appear and did not appear, and that constitutes the offense of absconding.
All right, so based on the facts placed on the record and from the information contained in the police report, court finds beyond a reasonable doubt that on April 27th of 2022 in the city of Adrian in the county of Lenawee, that the defendant, given prior notice of a pretrial conference, did fail to appear and therefore abscond or forfeit the bond in that criminal proceeding, and the court accepts the no contest plea. So, and then I think we're still gonna need an amendment information.
For the date.
I don't know about, yeah, probably for the date, but then we also need, I know you have it, the amended information to that file number 19-19686 for the count two.
I emailed it to Becky. So
Okay,
you should
got
have
it, all right. All right, has the court complied with MCR 6.302 B, C, and D? Mr. Malaro,
Yes, it has.
Ms. Meir?
It has.
All right, I accept the pleas. They've been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. Mr. Malaro, April 28th at 8:15 in the morning.
That's fine, Judge.
All right, so I will set these off for sentencing on April 28th at 8:15 in the morning. So, Mr. Roberts, someone from the probation department is going to meet with you to prepare a pre-sentence report. Make sure you fill out the packet. Make sure when you meet with them, you're truthful about your background and the events that occurred. And they'll prepare I know Miss Adams, I'll get to it, but they'll prepare a pre-sentence report. We'll send a copy to Mr. Malaro. He'll review that with you in advance of sentencing, and then we'll be back on that day. Now, he does have some really old contempt of courts on the 2019 files in light of the fact that he's pled. Do the people have any objection to me dismissing those contempts?
No, Your Honor.
All right, and Mr. Malari, I presume that you would have no objection to me dismissing those contempts.
No, no objection. Judge.
Okay, so we'll dismiss the contempt of courts. Now, Mr. Roberts, you do have the right to be present in person for sentencing, but you can also Zoom in. Would you like to appear via Zoom or in person?
I think I'll still be incarcerated, so I think I'll zoom in.
Okay, so we'll do that via Zoom. And anything further today?
Nothing on behalf of the people.
All right. Thank you, Mr. Roberts, Mr. Malaro, Ms. Meir.
Thank you, Aaron. Thank you, Sam.
Yep, no problem.
Thank
Carol.
you.